All rise. Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV22 0765, Arizona Creditors et al. Versus State Arizonans fed up with rising healthcare et al. Each side has 20 minutes for your argument this morning. The appellant may reserve time for rebuttal. I would just ask that you keep track of that yourself because we don't. So there's a clock on the other side. Our proceedings are being audio and video recorded here today, so please introduce yourself and your client at the outset of your argument. We've read the briefs, discussed the case in conference this morning, and are familiar with the arguments raised, so please keep that in mind when making your arguments. And with that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court. Brett Johnson, with me today is Tracy Olson. I will reserve 4 minutes, and I'll try to keep track of it, Judge. Appellants come before you today to address Proposition 209, an initiative that significantly revamped debt law in Arizona. Voters were promised that Prop 209 would only apply prospectively and would not apply to contracts entered into before the law's effective date. In the lower court, no party disagreed that this was what was promised to the voters, or that this is how the law should be read on the books. Unfortunately, the way this promise was textually memorialized in Prop 209 Savings Clause, it is not so simple. Instead, the drafters inserted vague and unintelligible instructions on how this promise actually applies to the post-judgment enforcement action it governs. Specifically, the Savings Clause tells us that Prop 209 does not apply to rights and duties that matured prior to the effective date. And separately, Prop 209 does not apply to contracts entered into before the effective date. They're mutually exclusive. When considered in the debt collection context, the first category tells us that Prop 209 applies to post-judgment enforcement actions based on some trigger after a final judgment is issued, because that is the earliest point in time a right or duty could mature.
Counsel, before we get further into the analysis, can we begin at the beginning with standing? Can you address there was a motion to dismiss below for lack of standing of plaintiffs, and there's a cross appeal on that point.
Thank you, Your Honor. And yes, of course. First of all, I am glad you mentioned that it was based off a motion to dismiss, and that's a 12B6 standard, which this court will also need to apply.
But eventually, the trial court consolidated the preliminary injunction hearing with the trial on the merits. So before you jump into the merits of standing, what impact, if any, does that procedural background have on our standard of review with respect to standing? And did it require you then to do anything more than just rely on the allegations in your complaint?
Well, it's relying on the allegations, but you could also rely on the record. But let me point out, Your Honor, that the other side did not raise that during the trial proceedings. It was just purely on a 12B6 motion. So basically that's waived here for these purposes. Now, of course, this court can address standing at any point too, and it's a de novo review. I think we all agree on the legal standard in that regard.
Was the verified complaint and the declarations attached to the verified complaint, were those admitted as exhibits into evidence at the hearing?
I believe the declarations were, the verified complaint was, and then in addition to the substantial record that was presented to the court as part of the preliminary injunction were then turned into exhibits for the trial court. Most importantly is the reflection of the true controversy, because I think that is a major point when you look at the court's precedent, both at the Supreme Court and this court. It is the controversy that is a major issue here. The other side obviously wants to concentrate is that there's not an injury in fact. It should be an as-applied challenges. Look at these cases that have been going through the justice courts and between the commissioners post, and it's reflecting that. But when you have an actual controversy, which is what we have here, and that's what the Superior Court determined was an actual controversy because of the uncertainty in the law, you have definitely standing. In addition,
And the uncertainty is how does the savings clause impact a pre-209 judgment when there's a post-209 garnishment proceeding, right?
that is one of the major controversies for sure, Your
Did
Honor.
you allege, or do you have any of your clients with evidence in the record that they are in that position now?
Well, in that position now, again, that would be going to an as-applied challenge that they would have to. But we have provided multiple records from both the Justice of the Peace and the commissioners, and those lawyers who are involved in those cases are members of ABCA, which is a plaintiff in this case. Therefore, based off of associational standing at the minimal, there is a controversy that is being brought before the court.
But you don't have a client that is in a pre-209, has a pre-209 judgment with a post-209 garnishment proceeding, right?
No, Your Honor, because this was a facial challenge. It was brought immediately after the effective date. Excuse me. Based off of that standard alone, once you have the controversy, and we saw that in FAN, we saw that in other initiative contexts, when there's uncertainty, you don't have to wait for an as-applied challenge as the government and the defendants are trying to make reference to.
But don't you have to at least be able to argue that that uncertainty is causing me injury now?
And it is, Your Honor. Every time a lawyer or a debt collector goes into a justice court or before a commissioner, they are rolling the dice to reflect what's the rules of the land, not as to the facts. The facts are what is to be garnished, what's the amount, all of those things. But what are the rules that a lawyer is supposed to do, or a debt collector is supposed to do, or quite honestly, the debtor? What are the rules that are going to apply here? And especially in this context, when the legislature has directed the administrator of the courts to give guidance to the parties of those proceedings. And why is that? Because of the small amounts that are at issue.
What's the imminent prosecution?
Well, well, Your Honor, I disagree that it needs to be imminent prosecution. All there needs for purposes of a controversy is potential further harm that is going to occur due to the uncertainty. And our argument is that you obviously have the FDCPA, which is a strict liability statute, and walking...
Is that the federal government?
That's the federal government.
So a different sovereign.
It's a different sovereign, but if you look at ARS 12-1845, which is the Uniform Declaratory Judgment Act, and of course we appreciate you have to have standing before you can trigger the Declaratory Judgment Act, it talks about uniformity of interpretation with federal law, that they should be all read in harmony. And in the cases the Strada case is another good example. When you have cases that are either applying in ordinances or state law, you have to read them together as one scheme because the penalties of the FDCPA are intricately tied to the state law and whether or not the debt collectors are following state law. So the liability under the FDCPA is intertwined with the state law, and therefore that is the penalty and the immediate risk of every lawyer and debt collector that's going into court.
So the prosecution is what, civil penalties?
It is civil penalties.
And have you received a letter from the government saying we're coming after you for this?
Well, it wouldn't be from the government, Your Honor, necessarily. It could be, but it could also be from the individual debtor or their counsel or a class action type lawsuit.
Right. Do you have that letter?
No, we don't have that letter, and we don't need to have that letter. For purposes of the controversy is the risk of that letter, and especially if you look at some of the cases, for example, Arizona Petition Partners, appreciating that was a criminal case. If you look at it, it's just the chilling aspect of it for purposes of controversy. If you're going to chill...
Well, the First Amendment.
Your Honor, what
are we chilling here? What's the constitutional right?
Conduct, Your Honor.
What conduct?
The conduct, the ability to go into court and make an argument on behalf of a client without risk of FDCPA violation.
And that would be, the ramifications of that are a civil fine from the federal government?
Well, it's three parts, Your Honor, and obviously that once you proven up an FDCPA case, there's three parts to it. Number one is actual damages. What is the difference that you should have had of actually applied between the debt? The second is a $1,000 penalty. And then you could also have punitive damages. And that's not in the abstract, Your Honor. FDCPA cases are brought all the time.
What about, okay, so facial challenge under Johnson, I guess you're saying the federal government, the Supreme Court has walked that back to most applications in order to bring a facial challenge. You have to demonstrate that most applications of this statute are unconstitutional. Is that your argument? That most applications? I mean, and then my other question is going to be, has Arizona adopted that yet? And can you give me the citation?
Well, Your Honor, I think that if you look at Brush and Nib and you look at some of those other cases, it doesn't have to be in all applications, because in Brush and Nib, there were some of the invitations that would have passed muster underneath that law. So it wasn't necessarily all applications. Do I think the majority of application? Yes, I think that that's probably the applicable standard under Brush and Nib. But under even that context is that if it was the reverse, if you just had a few instances where there would be ambiguity in the law, and that would not impact the way that the garnishments are here.
A few instances. That's what you're arguing now. The standard is for a facial challenge.
No, well, for a facial challenge, it's not a few instances. What I'm saying in that particular, in many cases, the legislature, and in respect also the people when doing the initiative, we agree that you don't have to have a perfect law, but you have to at least put some guidelines in place. You have to at least give the rules of the land. That's what's different here, in that we're not asking you to apply facts. We're not asking you to have a garnish sheet that's in front of you. What we're saying is, what are the rules to actually apply that? And when the legislature directs the administrator of the courts to take that action, and the administrator of the courts, which is in the record and was reviewed by the Superior Court, could not identify what the law of the land is under Proposition 209, that is showing the controversy that exists for which relief is necessary. Certainty.
Before we get too much further away, I just want to clarify, because you say in the opening brief that these matters are percolating through the courts now, back to the issue of standing, and have adversely affected plaintiffs who are involved in litigating these cases every day. When you say plaintiffs who are involved in litigating these cases every day, do you mean you plaintiffs or plaintiffs generally?
Well, as part of our plaintiffs, we have debt collectors. Right. Then we also have the attorneys that represent the debt collectors. And anytime a lawyer walks into court, they're underneath the jurisdiction of the court for purposes of contempt, and in cases of the FDCPA, making sure they're complying with the law personally. There's personal liability associated with that. So those are the plaintiffs that we're discussing.
Right. What I'm trying to get to the point that Judge Catlett brought up earlier, in terms of the harm specifically to you plaintiffs in this case.
Yes,
because so when you say adversely affected plaintiffs, are you saying those plaintiffs named in this action, or just plaintiffs in general in this world?
And I apologize. Plaintiffs in this action, in particular, the lawyers that are members of the ACBA, the lawyer who is one of the plaintiffs, the law office themselves, and the debt collectors that are present within the action. Those individuals demand and require certainty as to how to proceed when they're seeking garnishment or even a continuing lien on that garnishment.
Right, and those individuals have been adversely affected.
Yes, Your Honor, and you can see that even just by the record themselves, because of the different way that 209 has been applied. Again, every time that they're walking to court, they're rolling the dice.
Is count 3 in your complaint is a request for a declaratory judgment interpreting or to provide guidance on the pre-209 judgment and the post-209 garnishment proceeding. Is that claim independent of counts 1 and 2? In other words, if we were to rule against you on 1 and 2, are you still asking for the declaratory judgment under 3? My understanding is you are.
We are, and Your Honor, it makes sense. We think that the law is vague and unintelligible, right? The lawyers have difference of opinions. The commissioners, the justices of the peace all have different interpretations too. So if 3 of you disagree and say that the law is not vague and it's not unintelligible, then it's appropriate, especially under Title 12, to give declaratory judgment, because it specifically underneath that statute requires certainty and uniformity within the law.
But are you asking for it in the alternative?
We are asking for an alternative, yes, Your Honor, and we pled it that way, and it was also, I believe, in the briefing that way for sure, but definitely in the complaint it was alternative, because obviously you wouldn't need declaratory judgment if you struck down the vague law.
And for standing on count 3, so for counts 1 and 2, when I asked if you had a client that has is in a situation of a pre-209 judgment and a post-209 garnishment proceeding, you fell back on, well, that would be an as-applied challenge. These are facial challenges under counts 1 and 2. For purposes of count 3, don't you need to have a client that is in the pre-209 judgment, post-209 garnishment proceeding posture? In other words, so if we give the interpretation you're asking for, how does that benefit anyone if you don't have a client that's in that situation?
Well, we do have that client, and I think the Superior Court properly identified the uncertainty associated with 209 that led to the controversy at issue, because you still have standing and ripeness when you're talking about the Uniform Declaratory Judgment Act. Under those principles, the uncertainty as to both the members of ACBA as well as the debt collectors gives you the ability, those plaintiffs, to come into court and ask for declaratory judgment as to what they should be doing within the justice courts and the commissioners in seeking either judgment and as the writ of garnishment and which percentages apply to those garnishments. It's very important that there's uniformity within the law, and that's the whole purpose of the Uniform Declaratory Judgment Act, providing uniformity in the law. The declaratory judgment action allows the court, if you determine that it's not vague and it's not unintelligible, to give that declaratory relief to provide the administrative courts, the justices, and the commissioners that certainty.
On vagueness, are laws required to have a provision explaining prospectivity?
In this case, Your Honor, it would need to, because it was impacting contracts and because of the contract clause.
Right, but if it didn't, we would just presume that it would have prospective application only under ARS 1-244.
That's correct, Your Honor.
And then we would be in our framework for how we determine when a law is being applied prospectively and when it is not. So I think we look at, is it a procedural statute versus a substantive statute? If it's substantive, is it impacting vested rights or not? How is that situation any less vague than what is in the savings clause here?
Well, it's also what was promised to voters, right? So under your context, Your Honor, is that there's no savings clause. It's just applied prospective only, and you apply that standard of law. It's different here because of what was promised to the voters. It was promised that it was going to be prospective only. Maybe that was a reiteration of law and to avoid a contracts clause argument.
But was there a promise that there would be a statement that it was prospective only, or that there would be prospective application?
It would only be applied prospectively and after the effective date. That was both in the principal section, the 100 words, and then also in the savings clause itself. And then it specifically said, Your Honor, that it would not impact existing contracts. And that's where you have that conflict between subsection 1 and subsection 2, that they have to be read separately, unlike what...
So your position is that if we don't have the saving clause, then it cannot offer that protection? It cannot be applied prospectively only?
Well, you would, under what Judge Keller was talking about is that just as a matter of principle, it would be prospective only, but you would still run into the same confusion as to when it is actually impacted. That's the interplay of, and I see that I'm going to time real quick, Your Honor, but that's the interplay of the difference between an initiative and what the legislature is able to do. The legislature is able to go back in and fix some of the comments that Your Honors are bringing up. We don't have that situation here, and you have to look at it all as to one scheme, as well as looking at the 100-word summary and what is actually put into the body. They're the ones who frame this, and there's a lot of questions that are out there. If it's okay with Your Honor, I'm going to reserve the rest of my time. Thank you.
Thank you, counsel.
Good morning, Your Honors. Haley Crawford on behalf of the state of Arizona. The state and the interveners will split time equally. With the court's permission, I would like to reserve 2 minutes of my time for rebuttal on our cross appeal here on the justiciability issues. I think the court has hit the nail directly on the head here. The court is not a roving commission going out to hunt for constitutional infirmity. The court's role here is to hunt for constitutional readings. The presumption is that a law is constitutional, and we're going to try and construe it as such and give effect to a law that was validly adopted, in this instance by nearly 2 million Arizona voters. But what the debt collectors are asking you to do here is the opposite. They're asking you to look for particular circumstances in hypothetical as applied instances where there might be problems with this savings clause. That is not a facial challenge, and the court should not declare a law unconstitutional on its face as applied to everyone based on a hypothetical as applied instance in which it might be problematic. Excuse me. In fact, I think that the debt collectors really almost expressly concede that this truly is an as-applied challenge if you look at their briefing. In their reply brief on page 18, they say, plaintiff's theory is not that the savings clause is vague because of the presence of these multiple subparts that they say conflict, i.e. on its face. Instead, plaintiff's challenge is that in the appropriate context, Prop 209 subparts overlap and conflict so much that they are indecipherable. In other words, when you go to apply this savings clause, we're running into problems in some instances. That is not the standard for striking down the law as facially unconstitutional.
There are two plaintiffs, maybe three, that I want to talk about. First, I want to start with the HOAs.
Okay.
The HOAs say we currently have judgments. I'm assuming those are pre-209 judgments. I would also think that if you're holding a judgment, you're likely in the near future to try to enforce that judgment. And then if they do that, then they're in the post-209 garnishment world. Why is there not standing with respect to those two particular plaintiffs who say we currently own judgments?
Sure. Well, to begin with, I'm not sure where in the record it says that they currently own judgments.
I think it's in the complaint itself.
Okay. Looking at App 010, page 10, I believe it's paragraphs 12 through 16 is where we have the HOAs, and they allege that they routinely collect these sort of fees through judgments and garnishments proceedings, but I do not see an allegation that they currently have ones that they are in the process of collecting.
Paragraph 15 says Desert Ridge routinely collects, which you said.
It has current garnishment proceedings pending.
And has current garnishment proceedings pending.
Sure.
Desert Ridge has been and will continue to be harmed by the passage of Prop 209. And then that same language is repeated in paragraph 16 with respect to Augusta Ranch, that it has current garnishment proceedings pending.
So construing it most favorable to the plaintiffs, as we should, even if we assume that they have current garnishment proceedings pending, as you were discussing with plaintiffs' counsel, part of standing is requiring that there's some credible threat of enforcement. And there is no threat of enforcement under the savings clause as a matter of law. It's just not a law that imposes any penalties or regulates any conduct. An important thing with respect to the HOAs in particular, the plaintiffs rely very heavily on the FDCPA, the potential liability under that act. Now, to be clear, that does not impose any penalty. The federal government would not be sending you a letter saying, hey, we're imposing a penalty on you. All that does is create a risk of third-party liability. That would be a private lawsuit that would pose that.
Prop 209 is currently being enforced in the manner that it's effective. It's a law. They are bound by it.
Correct.
And I think their argument is, if we prevail on a facial challenge, the whole thing goes away. And that's a benefit to us because we are collecting on garnishments, and at the very least, we're going to be able to collect those garnishments quicker. Why is that theory? It's sort of a belt and suspenders theory, I guess, that maybe the vagueness itself isn't impacting us, but the law certainly is, and we benefit if the law goes away. And therefore, we can bring a vagueness challenge, particularly when I think courts have recently said, even if the law clearly applies to you, you can still bring a vagueness challenge. How is that not sufficient for purposes of standing?
Well, I think there's a couple different pieces in there.
That was a long question.
No, that's quite all right. So I just want to close the loop on the thing I was saying about the FDCPA. The FDCPA defines debt collectors. It only applies to debt collectors. If you are collecting your own debt, it does not apply to you. So if the HOA is filing garnishment proceedings on its own behalf, it faces no threat of liability under the FDCPA, period. So that the main source of alleged enforcement or potential injury that they're alleging simply doesn't apply to the plaintiffs that you've identified. So I think that defeats their standing in the first instance. The second point I would say is that that's not the standard for standing, simply saying that it would be to my benefit if a law goes away. I think that would eviscerate the standing requirement in Arizona entirely. And really, I think that's the problem with the plaintiff's position here, is when they're saying, all we need to allege for our pre-enforcement facial challenges is that there's some conflict in the laws and that we would benefit from the clarity. But if you look at the underlying case law, that's not what it says, and that would effectively write out any injury requirement. Excuse me.
I mean, our Supreme Court has taken a very broad view of standing recently, particularly under the Declaratory Judgments Act. I mean, you look at cases like Brush and Nib, Mills, the Arizona School Boards Association case, where they said it was enough that this particular bill might prevent local governments from passing mask mandates, and if they wanted to pass those, that would then have the downstream effect on the plaintiffs who were more susceptible to COVID-19. They said that was enough. And they even, in that case, they cite to a case from 1972 called State v. Direct Sellers Association, and our Supreme Court characterized that case as saying, or finding that, quote, a trade association, some of whose members conduct home sales solicitation, had standing to challenge the constitutionality of a home solicitation law.
Sure.
That seems pretty similar to what we have here. So I guess I would just welcome your comments on that.
Yes, Your Honor. I think that collapses the pre-enforcement challenge they're bringing and the declaratory judgment claim they're bringing. As they just clarified, these are separate and alternative claims, and I think that there has been sort of an expansion of the standing for declaratory judgments regarding the constitutionality of a statute. But their declaratory judgment claim is not seeking a declaration on constitutionality. They're seeking, effectively, an advisory opinion on how this should apply in the future in as-applied cases.
Well, counts 1 and 2 they're seeking declaratory relief that the statute is unconstitutional because it's vague. I mean, in the school board's case, they were seeking declaratory relief that it was unconstitutional because it violated the single subject rule.
Sure.
I'm not sure that's a material difference.
I think really for the pre-enforcement facial challenges, the standard for injury in fact and for standing is the one that we've cited from Dry House. Now, they say, we didn't cite the federal law before, so it's waived, but really, this is the standard. They don't meaningfully dispute that, and that requires you to allege that you're intending to engage in some course of constitutionally protected conduct and that there is some credible threat of enforcement. And they have not done either of those, as we've discussed in our briefing. So I think that really is the appropriate standard here. I think the declaratory judgment authorities that we're talking about are really more appropriately examined in the context of their third one. And I apologize, I would like to reserve the rest of my time for rebuttal on cross appeal if I may. Thank you.
May it please the court. My name is Jim Barton. I'm here on behalf of Arizonans fed up with failing health care. If we can move off of standing for a moment, if you will, I'd like to talk about the standard that applies when you're making a facial challenge based on vagueness. And of course, we cited the Hoffman case, Village of Hoffman Estates case, where it actually says that vagueness challenges, which do not involve First Amendment, that's not the case here, must be brought in light of the facts of the case at hand. So that suggests that you can't bring vagueness challenges as a facial. Maybe that's too much. We have from the Pham v. State case, where the Arizona Supreme Court has said if you want to challenge the constitutionality of a statute on a facial grounds, it has to be unconstitutional. There has to be no set of circumstances that exist under which the statute is constitutional. And the Ninth Circuit has said something similar almost every case, or you're challenging the law in its face. I believe these are all related because they ensure these statutes related to a facial challenge ensure that the person who is arguing the vagueness applies to them, and that they're not arguing someone else's vagueness case. In any case,
didn't the U.S. Supreme Court sort of cut back on some of that in Johnson and Sessions v. DiMaio?
They cut back on it. So in other words, it doesn't have to be in every single case, although our vagueness issue with a facial challenge to vagueness is still interesting precedent. But it has to be in every relevant case, or it has to, and of course the fan case would be the one that would apply that does actually still use the absolute language. In any case, we just do not disagree about the application of Prop 209 saving clause in every case or in nearly every case. In fact, at the appellee's opening brief in page 56, you'll notice that we agree that debt arising out of contracts entered into after December 2022, December 5th count. The Prop 209 applies. Judgments after December 5th, 2022 apply. We also agree that it doesn't apply to contracts entered into before December 5th, 2022. What we disagree on is what that means.
Do you agree that Prop 209 does not apply when you have a pre-209 judgment with a post-209 garnishment proceeding?
So Prop 209 would not apply to the December 5th judgment. So in other words, if you're talking about the interest rate that comes out of the judgment or something like that, if you do an enforcement action is not the judgment. An enforcement action is a separate thing. It's not the contract. It's a separate thing. So if the enforcement, and frankly, I will credit the creditor's brief does a great job of spelling out how writs of garnishment are a whole separate action. So in the example you gave, a writ of garnishment, you're looking at the writ of garnishment. Is this a contract? No, it's a writ of garnishment. Is it related to the judgment interest? Prong 3, no. So we have to go to prong 1. Is the rights and duties here, were they mature prior to the effective date of the act? No, they weren't mature yet, so the act applies. So the only disagreement
it depends on how you define the rights and the duties in that case. Is the right duty to pay the amount due on the judgment, or is the right and the duty to, I guess, hold monies for the benefit of the creditor, being the garnishee?
I think that, so I think this is we're getting to the important point that's raised in our briefing, that just because a statute is subject to multiple interpretations by judicial officers, that doesn't mean it's vague. It's only vague if they're not given a standard. So in this case, we've given the judicial officer a very clear standard, which is, has the right or duty matured in this specific case? And so the judicial officer will look at that and will decide, is this, it seems that, I know in some of the cases they say, when it's served, once the writ is served, that's the point when nothing else has to happen for the duty or right to be valid. For me, that makes sense. But in any case, other judges will look at the requirement that the right or duty have matured, and they might set it at an earlier date. And until we have a live case with a real contract and real writs of garnishment that comes up to be reviewed, I suppose we'll have that situation that we've talked about of where the contract is subject to, or where the term is subject to multiple interpretations.
When do you think the rights and duties mature with the garnishment proceeding?
Well, I will answer your question, but I'm hesitant to do so because I don't have a debtor client. So I would hate to have my words be used to secure the rights of someone. We don't have a debtor. There's no debtor in this case. So
That's all right. Your opinion is not precedent.
Thank you.
And your client wrote the law.
Thank you. They did. And so I believe that when we're talking about garnishment situations, it would be when the writ of garnishment is served. And that's when nothing else has to happen. Now that third party, it can't be when the contract was entered into, because the garnishor was not a party to that contract. So they're like totally unrelated until they get the writ. So I actually think, and actually if you look at the supplemental precedent or authority that was provided, that's what you'll see. That's the only question, is how do we interpret this clause that says that it does not apply to contracts entered into before the effective date. Our view is that means the terms of that contract. The contracts that are entered into cannot be reformed. We're not going to go back and change the terms of a contract. In almost every case that I can think of, post-judgment relief based on a contract is different from that contract. It's not the same thing. Unfortunately, because again, there's a facial challenge and we're dealing with hypotheticals, I suppose we could think of an example of where a contract term maybe would touch on post-judgment relief in a very explicit way. Well, that would be a different case than the hypotheticals we've talked about up to date, where maybe that would be amount to changing the term of a contract. But in the garden variety, again, remember it's a facial challenge, so we're talking about the vast majority of the cases that this deals with. The terms of a contract are clear and distinct from an enforcement action that comes after. And I want to point out, by the way, that that's why there's no conflict between the three prongs of the savings clause. There literally can't be. They each give a reason why as an example of when prospective application would kick in. So if prong 1 says Prop 209 does not apply, and prongs 2 and 3 say it does, or more accurately, do not say it does not apply, well, then it doesn't apply because of prong 1. And if prong 2 says it and not 1 and 3, it doesn't apply. That's just how a savings clause works. And that's, frankly, that's also why you can't say it's incomplete, because it is complete in that it has given you the times when the savings clause would kick in. So I think that...
Why include the savings clause at all when we already have a framework, a legal framework that applies to determine whether a law is being applied prospectively or not?
Right. Well, as this case gives evidence, initiative proponents spend millions and millions of dollars to put these things on the ballot, and they spend millions and millions of dollars to urge voters to vote for it. And they are constantly subject to basically any challenge that anyone can possibly think of. So there is an effort to use belts and suspenders. There is an effort to say, well, let's just make sure. You're right, Your Honor. We could have left the savings clause off altogether, I suppose, which, by the way, we're so many layers in.
It would have made it much harder for your client to market this initiative to the people of Arizona as not impacting current contracts.
Well, I don't have polling data, or I don't have anything.
It's a way of saying this seems like a pretty material provision, and if we think it's unconstitutional, then doesn't the whole law need to fall?
Absolutely not. If you think the savings clause is unconstitutional, we have a severability clause too, which has not been challenged as being vague. So you would strike the severability or the prospective only clause, the savings clause, and then you would still have the savings clause because of the statute. I want to point out that what we talked about in the Hunterwood description was making it clear that although we were protecting you from these kinds of post-judgment attacks on your property, it didn't affect things like car loans. It didn't affect mortgages. So what we said is it doesn't affect secured debt, contracts that are based on secured debt that was already in place. And that was intentionally, again, because we've had a whole bunch of challenges about Hunterwood description. We want to make sure that no one thought that they could stop, if they signed this petition, they could stop making their mortgage payment because it would be protected from that. No, it was an effort to address the people. I started to say, I don't have polling data, I don't have information around this, but I do not believe that the presence of this savings clause was somehow the motivation behind people voting for this measure. I think there's nothing in the record to say that. And I do want to point out, and we did this at the answering brief at pages 18 and 19, how common this language is. It is literally the language that the Legislative Council puts in the drafting manual on what a savings clause is. So I think all of the standing issues, all of the facial challenge, it's not a penal statute, all that stuff aside, it's not vague. It is just not, and I ask that you affirm the court below. I'm going to reserve the remainder for my colleague on rebuttal.
Obviously, I'd like to thank Mr. Barton for showing the ambiguity and vagueness around this law, but it also leads back to, I think, a big part of our original argument about standing. Arizona is a prudential state. We don't follow the federal standard. When there is something of statewide importance and members of the bar are coming before this tribunal asking for clarity as to the rules of the game, that's all they're asking for. If it's vague, then it's unconstitutional and should not be applied. If it's not vague and it's not unintelligible because it's missing language.
Well, counsel, prudential statute says we exercise restraint and refrain from issuing advisory opinions to ensure that cases are ripe for decision and that issues are fully developed between true adversaries. Yes, we don't have Article 3. We don't have that constitutional standing requirement, but why doesn't prudential standing, how does that, you get past that rather than Article 3?
Yes, Your Honor, and it's very clear. This is a facial challenge dealing with the face of the law as applied. It's that simple. All you have to do is look at the savings clause itself. So from a facial challenge of a constitutional issue as to whether or not what conduct is going to be controlled in the lower courts is what is at issue. And as we put in the record, it was before the Superior Court, 14,000 cases in 2021. dealt with this specific issue as to garnishments and continuing liens. And what was missing from Mr. Barton's presentation in any context was that still the writ of garnishment and the continuing liens, you only get there from a contract. You only get there from a judgment on the contract. And by eliminating and trying to separate that...
I mean, I can get there because someone ran into the back of my car and I got a judgment.
And
that doesn't involve a contract.
That doesn't, but for purposes of what we're trying to, that is one of the issues that the Superior Court ran down a rabbit hole, right? Is trying to understand what matured rights were under Section 1. But our case and what we brought up on appeal is very simple. How does this apply in the context of contracts in regard to judgment and writ of garnishment? When, under the Savings Clause, is the actual trigger date? That is the certainty. Can I have one more second, Your Honor? So that is the certainty.
25 seconds.
25 seconds. I appreciate that, Your Honor. And the reality here, Your Honor, is that the law, as we've seen, it's vague, it's unintelligible because it's missing stuff. The Superior Court had to rely on 1986 legislative language to get to where it is. But at the end of the day, the court still has the ability to give declaratory judgment. And if the court is so inclined, the certainty that will be provided to the rest of the bar as to what the rules of the game are would be greatly appreciated. Thank you.
Thank you, counsel.
I'll be brief and I'll focus on justiciability here. Standing is defined by the substantive claim at issue. So we talked a little bit about there's the pre-enforcement facial challenges, and then there's also the alternative declaratory judgment claim, and we talked a little bit about the varying standards for those. But ultimately, you have to look at the substance of the claim that they're bringing to determine whether they have standing.
Prudential standing?
Correct. So to determine how you evaluate standing and whether there has been an injury, whether there's a controversy in fact, you have to look at the claim they're actually alleging here. And in particularly with respect to the request for a declaration about the constitutionality or about how these claims, how the Savings Clause applies to various claims, I think Hunt v. Richardson, which is 216 Arizona 114, Court of Appeals case from 2007, is particularly instructive. There, the court held that the plaintiffs who were seeking a declaration about their potential future liability to third parties for failure to maintain an easement, they said that was not justiciable. That's exactly the case we have here. We don't have any particular debtor or creditor before us. We don't have any particular applications of Prop 209. They are seeking a hypothetical abstract advisory ruling without any present controversy.
Why are the HOAs not judgment creditors when they say we're holding judgments and conducting garnishment proceedings?
Because they have identified no threat of enforcement or potential liability that they face as the result of the application of this statute. Remember, the FDCPA does not apply to them at all. So their default position would be, it would be better for us, or we'd rather not have to litigate these as applied and have a bright line rule, but that's not what declaratory judgment is for. Thank you, Your Honors.
Thank you.
Thank you. Thank you both for your excellent argument. We will take the matter under advisement and have a decision issued in due course. We are adjourned.